thank you all very much for coming along to this talk about some aspects of the law of privilege that in our experience can be particularly troublesome for lawyers. And one obviously likes a talk to have a contemporary slant, and we'll be discussing one or two more recent decisions as well as some old favourites, because major decisions on privilege continue to pour out of the Court of Appeal at an almost alarming rate. The first thing to say is that I was to be delivering this talk with Chris Greenwood, but he's been temporarily reduced by some terrible lurgy to a shadowy husk of his usual robust self. So, to his bitter chagrin, and having done much of the work, he can't be here today. But before you all scramble over the backs of your chairs in a rush for the exit, I can confirm that Tom Asquith has stepped into the breach to cover the topics which Chris was planning to cover. So you'll be, in fact, getting the benefit of a kind of combined Greenwood-Asquith job share dream team at no extra cost. And our overall theme today is what happens to privilege when a solicitor faces a claim or application made by someone who is not a former client. And I'll look at some of the exceptions to privilege and how they can, in practice, be sensibly handled by solicitors. And then Tom will look at the particular problem of joint retainers, and also at the possible consequences if solicitors are unable to defend themselves properly without deploying privileged material. Now, in the ordinary run of litigation, solicitors make claims to privilege on behalf of their clients all the time. Those claims are capable of giving rise to difficult issues, but the procedures for resolving them are reasonably straightforward and well established. And slightly less common, but alas far from unusual, is the waiver of privilege implied in a former client's pursuit of a claim against their former solicitors. The basic rationale and thrust of the implied waiver are familiar, and again, relatively straightforward. It enables the solicitors to defend the claim. Obviously, at the margins, there can be difficult issues about the scope and duration of that waiver. But today, we're looking at the rather different problems posed by claims or applications made by non-clients, or only one of a number of clients, against the solicitors personally. And since solicitors in their dealings with third parties are usually acting as agents on behalf of their clients, and usually owe, as Roger was pointing out, no duty to anyone but their clients, claims by third parties against solicitors are not very common, but as we all know, they happen. And in those sorts of cases, what can or should solicitors do with the documents on their file, or indeed with other information in their possession relating to their clients' or their former clients' affairs? An initial question is obviously going to be whether the relevant documents are prima facie privileged at all. And not all documents on the file are privileged, and non-privileged documents may include correspondence, financial records, pre-existing documents, including non-privileged attachments to emails which are themselves privileged, transactional documents as opposed to draft transactional documents, and some kinds of metadata. For example, the identity of individual solicitors involved in the case, or indeed sometimes the identity of the clients, or diary entries showing the dates of appointments, etc. But remember that most documents on a solicitor's file will be confidential even if they aren't privileged. And unlike legal professional privilege, confidentiality affords only limited and qualified protection to documents, and there are well-established limitations which allow the disclosure that is necessary either in the public interest or in the protection of legitimate private interests. So confidentiality is not ahead of privilege against disclosure, but it can't be dismissed as irrelevant because there is high authority, Science Research Council and NASA and British Steel Corporation, to the effect that courts should order the production of confidential documents only when production is necessary in the interests of justice. And obviously in practice, there's a spectrum of respect which is afforded by the court to confidentiality, and a party's bank balance will not be treated in the same way as a non-party's medical records. So although our topic today is privilege, be careful of assuming too quickly that solicitors don't have to worry about the non-privileged. By contrast with mere confidentiality, as we all know, the protection given by legal professional privilege is absolute. But that doesn't mean, as we also know, that it's not subject to exceptions. I'm going to look briefly at 4 prominent exceptions. The first is not really an exception, but it has the same effect as an exception, where the applicant claims to be the successor in title of the client. Secondly, where the SRA gets involved. Thirdly, where there's been a previous waiver of privilege by the client. And fourthly, and this is topical, the iniquity exception. So starting with successors in title, you can't assign a right of privilege, but you can, in some circumstances, literally inherit one. For example, the successor entitled to real property, whether by inheritance or purchase, can assert privilege in advice which was obtained in relation to the property by their predecessor. And it follows that in some circumstances, they can use their right to defeat an objection to their inspection of such advice. Similarly, with the assignee of a cause of action, one can't assign a right of privilege, but a right of privilege may nevertheless accompany the assignment of a cause of action if, for example, the assignor obtained legal advice about the cause of action. And then thirdly, the new trustees of a trust stand in the shoes of the former trustees in respect of advice which has been obtained for the benefit of the trust. Now, obviously, there must be some limits to this doctrine of privilege by inheritance. In the case of trustees, there's a clear, if not always easy, distinction between advice obtained for the benefit of the trust and advice obtained for the benefit of the trustees personally, the former being inherited by the new trustees and the latter remaining with the old trustees. And a similar distinction must apply also to the other examples. The devolution of privilege is likely to depend ultimately on the purpose for which the advice was originally sought by the predecessor in title. But many solicitors will have come across the situation where someone, who they don't recognize as the client at all, sends a letter or even perhaps turns up at the door purporting to insist on the client's right of access to the file. Under Section 44B of the Solicitors Act 1974, moving on to the SRA is empowered by notice to require solicitors to provide information or to produce documents if satisfied that it's necessary to do so for the purposes of investigating misconduct. And it's long been accepted, though the grounds of the principle have been controversial, that the client's privileged documents are not exempt from production to the SRA. A few points worth noting in relation to that. First of all, the Bar Standards Board presently claims similar powers for itself in respect of privileged information in the possession of barristers. But that's a relatively recent innovation in the Bar Standards Board's approach. It appears, according to the guidance that has been issued in the Code of Conduct, to be based on reasoning which has now been called into question by a more recent authority, in particular the Court of Appeal's decision in FRC and Sports Direct, and it's arguably open to re-examination. In FRC and Sports Direct, the Court of Appeal firmly rebuffed a suggestion by other non-legal regulators that legal privilege is somehow not infringed when regulators are provided on a confidential basis with legally privileged information without the consent of the client. So the SRA and quite possibly also the BSB are in a special position. It's important to remember that solicitors should not volunteer privileged information to the SRA in the absence of a statutory notice. In the recent case of SRA and Williams, Mr. Justice Julian Knowles held that clients were entitled to anonymity in the published judgment of the Solicitors Disciplinary Tribunal on the basis of their rights of privilege, which the judge held had not been waived and which remained absolute. So the judgment proceeded on an assumption that disclosure by the SRA through the SDT did not itself infringe privilege. Now that assumption was clearly not going to be challenged on the appeal, because the only party to the appeal was the SRA itself. But it's an assumption which may be open to question. And one sees that in FRC Sports Direct, the Court of Appeal dealt with that issue in a very circumspect and gingerly manner. And it certainly seems arguable to me that just because documents may be used by a regulatory body for investigative purposes, it doesn't necessarily follow that they can also be deployed in formal proceedings before a tribunal. Waiver, of course, take place in a wide variety of circumstances. I've already briefly mentioned the implied Lillicrap or Paragon Finance waiver. Another, perhaps the most common, is the waiver which results from the deployment of privileged material in litigation. But privilege may also have been waived at some point in the past before litigation was even commenced, either in standard form contractual documentation or in communications between the solicitors and third parties which are authorized by the client. And then iniquity. And the iniquity exception is linked to the old principle that there is no confidence in iniquity, to use the phrase from Gartside and Outram back in the 1850s. And it's been the subject of very recent consideration by the Court of Appeal in Al-Sadek and Deckert, a case in which it was alleged that privilege in communications between Deckert and its client, a United Arab Emirates government, was undermined by the government's alleged kidnapping, unlawful detention, torture, and other forms of ill treatment of the claimant, Mr. Al-Sadek. And Lord Justice Popplewell conducted a detailed analysis of the iniquity exception, and he summarized its application in this way. And I'm sorry to have set you an optician's eye test. I'll read it out. The principal juridical basis for the exception is that it is a necessary ingredient of legal professional privilege that the communication should be confidential, and that the iniquity exception applies where and because the iniquity deprives the communication of the necessary quality of confidence. Communications between a lawyer and client, or with third parties, are confidential if they take place in the usual course of the professional engagement of a lawyer, notwithstanding that the engagement may concern an iniquity. This is why the iniquity exception does not apply to the ordinary run of cases. Such privilege is not prevented from attaching merely because the solicitor is engaged to conduct litigation by putting forward an account of events which the client knows to be untrue, and which therefore involves a deliberate strategy to mislead the other party and the court, and to commit perjury. Accordingly, the touchstone in distinguishing such cases from those where the exception applies is whether the iniquity puts the conduct outside the normal scope of such professional engagement, or is an abuse of the relationship which falls within the ordinary course of such engagement. So there's a high hurdle before the iniquity exception will be applied. And if you look at the cases in which parties have sought to apply it, I would say that perhaps 4 times out of 5, the court rejects the iniquity argument and decides to uphold privilege. Where the iniquity principle is engaged, what is its effect? Lord Justice Popplewell held that there is no privilege in documents and communications brought into existence as part of or in furtherance of the iniquity. These are 2 categories, either of which is sufficient. Part of will include documents which report on or reveal the iniquitous conduct in question. So in contrast with the test for the application of the principle, which is a stiff test, the test provided for the scope of the principle when it applies is comparatively broad. And importantly, it's not temporally limited to documents which are created before or during the iniquity. Now these conclusions on, first of all, the applicability, and secondly, the scope of the iniquity exception, assuming that they're not revised by the Supreme Court, lead to some nice distinctions which could be difficult for solicitors to apply in practice. Because as the Court of Appeal went on to say, it may be important to distinguish on a document-by-document basis whether the exception applies in the first place. To take a hypothetical example in the context of the present case, Suppose that Deckert held a document which recorded information about unlawful conditions in which Mr. Al-Sadek was being or had been held. If that information came to be obtained simply as an incidental consequence of Deckert's general retainer in the investigation, it would be part of Deckert being an innocent tool in the course of their clients perpetrating an iniquity, and the exception would apply. The document would be disclosable as being one created as part of and revealing the iniquity. If, on the other hand, the information were provided for the specific purpose of seeking Deckert's legal advice on whether the detention was or had been lawful, it would not be disclosable. This is not a function of the scope of documentation caught by the exception where it exists. Such a document would just as much reveal an iniquity as in the previous example. The reason it would not fall to be disclosed is because the iniquity exception would not apply at all. The example given would fall within the ordinary run of cases, in which, so far as the specific document is concerned, the relationship was not an abusive one. But how is a solicitor to decide on a document-by-document basis whether a document is obtained as an incidental consequence of a general retainer or for the specific purpose of obtaining advice? It may seem a bit far-fetched, but one can imagine retainer letters being drafted at the outset of the retainer in terms that required the solicitors to advise the client if any documents obtained from the client were suggestive of impropriety. Might that then bestow on them the cloak of privilege, which would otherwise not exist? In any event, an understanding of the substantive law of the exceptions to privilege will get solicitors only so far, because very often the real difficulties of claims or applications by non-clients lie in the practicalities. And here are 4 questions which often arise. How do solicitors get their own legal advice? To what standard does an exception to privilege have to be proved? To what extent can or must solicitors themselves decide controversial issues of privilege relating to the affairs of their clients or former clients? And can solicitors protect themselves against the consequences of getting it wrong by involving the client? Looking at those in turn, obtaining legal advice, there may be, as you'll of course be aware, a real issue over whether solicitors can use their file for the purposes of getting legal advice. Would the solicitor's disclosure of documents on their file to their own lawyers constitute a breach of privilege in itself? And it's unfortunate that what's generally regarded as the leading case on this issue, Quinn Direct Insurance and Law Society, was decided in the context of a very ambitious application. You could even call it a brave application by an insurance company for disclosure from the Law Society of the files of an intervened solicitor's practice relating to other cases with a view to obtaining material that might enable the insurer to avoid cover in the case with which they were dealing. And the judgment of the Court of Appeal is usually seen as preventing solicitors from disclosing to their own lawyers the privileged documents of their clients unless there has been a prior waiver of privilege. That may, in fact, not be quite right. The first point is that in Quinn Direct, the issue which was directly raised concerned the alleged entitlement of solicitors to disclose privileged documents not to their lawyers, but to their insurers. Although, obviously, that's a distinction of limited use to panel solicitors who are instructed by insurers on a firm's behalf. But secondly, the Court of Appeal expressly recorded that the applicant had not argued that an implied term in the solicitor's contract of retainer permitted such disclosure. So that argument was expressly left open for another day. Thirdly, even if solicitors are not entitled to provide privileged documents to their lawyers in defense of their own interests, they may at least be entitled to do so in order to obtain advice about the proper performance of their obligations of confidentiality to their client. And in the wasted costs context, it's notable that Mr. Justice Neuberger in Brown and Bennett and Mr. Justice Briggs in CS against Taylor Both suggested that it was a matter of choice for the respondent solicitor's counsel whether or not to look at the solicitor's file. And in the latter case, Mr. Justice Briggs said in his judgment that I had sensibly chosen not to look at the file, whereas, to be frank, it had not in fact occurred to me that I could do so. And finally, since the decision in Quinn Direct, it has become not unusual to include express provisions in solicitors' standard terms which permit them to disclose privileged information on a confidential basis to their insurers and or to their own lawyers. So it's always worth checking the standard terms, as always. But as is so often the case in this area, an important aim for solicitors is inevitably going to be the avoidance of unnecessary disputes. And in many circumstances, a firm will do better to proceed on the basis that they shouldn't disclose any confidential information from their file to their lawyers unless and until they've obtained the consent of their former client, or if they think they'll get one, an order from the court. The second difficulty facing solicitors is epistemological uncertainty, because solicitors are plainly under a duty to defend a valid claim to privilege. But in circumstances where the validity of a claim to privilege may depend on contested issues of fact, how can the claim's validity be determined? Now, that was another of the central issues addressed by the Court of Appeal recently in the Deckert case, when considering what earlier authorities had meant by saying that there must be a prima facie case, or a strong prima facie case, or even a very strong prima facie case of iniquity before the iniquity exception to privilege applies. And the Court of Appeal held the merits threshold for the existence of iniquity, which prevents legal professional privilege arising, whether legal advice privilege or litigation privilege, is a prima facie case, which means that on an assessment of the material available to the decision maker, whether that be the party or its legal advisor conducting disclosure or the court, it appears more likely than not on a balance of probabilities that such iniquity exists. In an interlocutory context, there is no distinction to be drawn between cases in which the iniquity is one of the issues in the proceedings and those where it is not. This is subject to the proviso that there might exist exceptional circumstances which could justify a court taking the view that a balance of harm analysis has a part to play. And that last reference is a reference, obviously, to the American cyanamide approach. Now, one can sympathise with the Court of Appeal's wish to get away from a Goldilocks and the Three Bears approach of looking for a case with just the right amount of prima facie strength, not too much, not too little. But there is a real problem in adopting a balance of probabilities test on summary applications, which is that the parties are inevitably going to be encouraged to engage in a mini-trial to pile in with all their evidence and satellite litigation results. And the difficulty of using the balance of probabilities to determine summarily a dispute which depends on contested issues of fact has resulted in other areas in a rather more nuanced and complex approach. And Lord Justice Popplewell, for example, expressly referred to the test which is applied on applications to serve out of the jurisdiction, where the court adopts a multifaceted process and considering which side has the better argument. But in the Deckert case, the Court of Appeal deliberately rejected that and other possible options in favour of a straightforward balance of probabilities test. The third problem is that in most cases, solicitors, if only for prudential reasons, would prefer not to sit in judgment on their clients' or former clients' claim to privilege. And two related questions arise. First, are solicitors required to raise an arguable issue of privilege for the court and leave it for the court to determine? And secondly, are solicitors entitled to adopt that course? And on the first question, there are authorities now pointing both ways. Certainly until recently, the Court of Appeal's decision in Adelsey and Denton's Europe, in which Lord Justice Lewison cited with approval Mr. Justice Blackburn's dicta in an earlier case at the end of the last century, the answer was yes. And the dicta cited by Lord Justice Lewison were to this effect: it is the lawyer's duty to claim the privilege on behalf of the client or former client whose privilege it is, at any rate where it is at least arguable that the privilege exists. So quite a low threshold there. But then, on the other hand, very recently, the Court of Appeal in Al-Sadek and Deckert suggested that it was adopting the balance of probabilities test, in part because a relevant decision maker, such as a solicitor, such as Deckert, would find the test straightforward to apply. There was no suggestion that Deckert were obliged to assert their client's alleged privilege, regardless of their own view of the merits of the claim to privilege. And if one considers the issue as a matter of principle, it's difficult to see why solicitors should be under a duty to maintain a claim to privilege which is arguable, but ex hypothesi, ultimately incorrect. A proviso to that effect wouldn't pass the necessary or obvious test for the implication of contractual terms. If the relevant information turns out to be not privileged but merely confidential, then there's no breach of confidence in the disclosure because the disclosure will be justified in the public interest and or required by law. The SRA's Code of Conduct requires solicitors to keep their clients' affairs confidential, but does add the crucial rider unless disclosure is required or permitted by law. And finally, solicitors are officers of the court, a point which was seized on by Mr. Justice Trower in the case of A and B to differentiate the position of an auditor. But it seems unlikely to me that the duties of an officer to the court include a duty at their client's behest to pursue a claim to privilege in which the solicitors do not themselves believe. So if a firm of solicitors decides correctly that their former client's privilege is not engaged, it doesn't seem to me right that they must nevertheless seek to uphold privilege because the client's claim to privilege is at least arguable. But even if solicitors aren't obliged to maintain an unlikely claim to privilege on behalf of a client, except in the most obvious cases, they're usually reluctant voluntarily to assume the risks inherent in misjudging the issue. And those risks obviously include the risk of liability for breach of confidence if they get it wrong. So are solicitors entitled simply to assert their client's claim to privilege and to leave it to the court to determine the outcome? Well, unsurprisingly, there's no authority to the effect that solicitors can maintain a claim to privilege which is not properly arguable. So solicitors themselves will always have to consider and reject thoroughly implausible claims to privilege. Secondly, solicitors who find themselves under a direct personal duty of disclosure, for example, as parties to litigation, like Deckert in the Al-Sadek case, or as recipients of a statutory notice, like the auditors in A against B, may also have to form and act on their own view of a claim to privilege. And in those circumstances, the Court of Appeal's recent decision in Al-Sadek suggests the courts may now be less willing than before to accept that solicitors can simply rely on claims to privilege which are merely arguable. On the other hand, one would expect a court to remain sympathetic if solicitors were able to show that they were genuinely unsighted on a particular issue, such as the alleged existence of iniquity to which they themselves had not been a party, or, for example, in relation to litigation privilege, the dominant purpose of correspondence which they themselves had not written and were not responsible for. By contrast, finally, solicitors who are responding to disclosure applications that depend on an exercise of the court's discretion in favour of the applicant, for example, under CPR 3117, the non-party disclosure provisions, or the Norwich Pharmacal principle, are less likely to be criticised or penalised in costs for withholding consent to disclosure and in insisting on a court order. And finally, a solicitor's best route to self-protection against costs and other risks when faced by a claim or application by a non-client often lies in engagement with the client, who is by now probably a former client. For example, there's authority to suggest that solicitors are under a duty to inform their clients of any disclosure application in respect of the client's potentially privileged information. In any event, it's nearly always sensible for them to do so. I'm putting to one side there, obviously, the tipping off provisions in relation to money laundering. Many potential problems can be circumvented entirely if the client's consent to disclosure is sought and obtained. If the client is unwilling to waive privilege and objects to disclosure, then other potential problems can be circumvented if the client decides to take part directly in the relevant proceedings and to take on itself the burden of resisting disclosure. And even if the client cannot be persuaded to participate in the proceedings, the solicitor's expression to the court and to the other parties of concern about privilege is likely to carry much more forensic conviction if the client has actually been consulted and has actually raised objections to disclosure. And finally, if the client's insistence on a doubtful, or perhaps even worse than doubtful, claim to privilege causes serious concern to the solicitors because of the concern about a risk of a subsequent claim, it may be possible for the solicitors to seek preemptive declaratory relief against the client. Obviously not the port of first resort, but as a last measure. And I'll now hand over to Tom, who will talk about joint retainers.
As Charles mentioned, poor Chris has had to hand over all his hard work to me at the final hurdle. So apologies to those of you who came to see the star is billed and have been left with the understudy. My or Chris's part of the talk is going to cover two main parts. The first is the issues which arise for claimants in the context of joint retainers. And the second is the difficulties faced by defendant lawyers when trying to defend claims when they want to use privileged documents. Turning to the first of these, solicitors and barristers frequently act for more than one person. They might have joint retainers or separate retainers on related matters. Examples might include acting for multiple claimants in personal injury litigation, or for family members in the private client context. Corporate lawyers might act for various partners or different shareholders, and panel firms might act for insurers and insureds. What happens when only one or some of the clients, or their successors in title, bring proceedings against a professional and documents relevant to that action are privileged? The first consideration is to examine what is the nature of joint legal professional privilege. The first key point is that clients who share joint legal professional privilege cannot rely on it against each other if they bring claims against each other. The second key point is that for privilege to be waived, it must be waived jointly and not by one client alone. Privilege as against the world, that is. Sometimes a client or former clients will want disclosure of documents which attract joint privilege because they've lost them, or they never had them in the first place for some reason. Or perhaps the applicant is a successor in title, in the manner Charles described. In those circumstances, the fact that the other clients have not waived privilege does not provide a basis on which the document holder, say the lawyer, can resist disclosure. That's because there's no way those clients could have relied on that privilege as between themselves, and so the defendant professional cannot pray and aid that argument for them. There are nevertheless steps that the solicitor can and should take when faced with such an application. First, in the case of a successor in title, it's important to consider what exactly has been assigned or otherwise transferred. If a solicitor handled two matters for a client, but an applicant was a successor in title of only one of them, the application should succeed or be consented to in respect of only that one matter. Secondly, it's important to identify any documents which do not relate to either the applicant or the predecessor in title or any generic or common issues. Some documents will relate only to other former clients. For example, in a loss litigation claim in which there were several claimants bringing claims for personal injury, there may be documents which contain advice on general strategy, and they may be disclosable, but documents which pertain to an individual's medical records or their own quantum claim may not be. Thirdly, a solicitor will want to ensure that any order is carefully drafted so as to exclude such categories of documentation. And fourthly, where any documents are disclosed, it's worth considering the setting up of a confidentiality club specifically excluding parties who are not entitled to see the disclosed documents. If you're acting for a private client lawyer and consider that there should be disclosed documents to one sibling of former clients, but anticipate another sibling who is not entitled to see the documents will try to get their hands on them, it would be wise to draft a non-exhaustive list of persons to whom the documents should not be shown, specifying that person. Some applicants will not have been party to a retainer, but will assert that they were owed a duty of care at common law. Separate to the issue of disclosure and inspection is the issue of deployment. Would a claimant be able to deploy rather than merely inspect documents absent a waiver of privilege by all clients or former clients? Generally, the answer will be no. Each client is entitled to claim privilege as against the world, just not each other. So solicitors who are ordered to disclose documents to a former client, where there's been a joint retainer previously, and there hasn't been a waiver or consent from all of those former clients, should make sure the terms of the order make it clear. There will still be reasons why a claimant might want to obtain disclosure and inspection of documents subject to joint privilege, even if they can't deploy them. It may be useful to help them find ways of accessing the same information in other documents which they may be entitled to deploy because no privilege attaches to those documents. Also, the claimant may be able to argue that there should be an exception to privilege in the particular circumstances of that case. So the first section of my part of the talk addressed the difficulties faced by claimants when wanting to rely on documents to which joint privilege attaches. And this second section addresses the difficulties faced by defendant lawyers who want to rely on documents to which joint privilege attaches. There is powerful authority for the proposition that unless the solicitor has obtained a waiver or consent from each named client, they cannot rely on the privileged documents in court. The first step is then to seek consent from the remaining clients, i.e. those who have not waived privilege through bringing their own claim. Even if a full waiver cannot be obtained, a waiver might be obtained at least for specific purposes. But what if that proves to be a dead end, because the clients are untraceable, unwilling, or actually dead? What then? There is no clear answer. The non-consenting client does not need a good reason to hold back the documents. As made clear in this citation from Adelsey, it doesn't matter what the reasons are for the client's non-consent. The lawyer's mouth is shut forever. There can be real hardship, therefore, on the defendant lawyer, and this possibility has been recognised by the courts, see Crown and Derby, without any solution being postulated. The sanctity of the privilege rule would be of little comfort to the lawyer handicapped in her defence of a claim against her. Shockingly, this pressing issue hasn't been grabbed by any major party to headline their manifesto, despite it being an obvious vote winner. So whilst we wait for the Lawyers' Immunity Bill exceptions from privilege, here are 3 possible suggestions to help in the meantime. First, the lawyer could argue that the claimant client is able to, and has in fact, waived privilege on behalf of the non-claimant client. Secondly, the lawyer could argue that where there is doubt on any particular issue, where privileged material might have been helpful, he should have the benefit of that doubt. And thirdly, the lawyer might argue that the claim should be stayed or struck out. Turning to the first of these, the basis for the implied waiver can be found in Liddycrap and Nalder. The key paragraph, I think, is the third one. The waiver must go far enough, not merely to entitle the plaintiff to establish his cause of action, but to enable the defendant to establish a defence to the cause of action if he has one. Can the lawyer argue that a claimant has waived privilege by bringing a claim, not only on behalf of itself, but also on behalf of a non-party? Some assistance might be gained from the language used in Pharmacist. See the focus on fairness. Would it be fair for a company to rely on privilege if the owner and controller of that company was bringing a claim against a solicitor and that claim could only be fairly defended with reference to material which was generated during a joint retainer, where the solicitors acted for the owner and the company itself. If the answer was no to that question, claimants might be incentivised to ensure that not all joint clients were party to a claim, particularly those with no or minimal loss. The second possible route, the one involving the benefit of the doubt being granted to the lawyer, is essentially to draw an analogy with the wasted cost regime. That jurisdiction also involves consideration of a lawyer's allegedly negligent act or omission, and also an application for wasted costs against another party's lawyer does not waive that other party's privilege. As noted in Medcalf and Mardell, that means that the respondent lawyers may find themselves at a grave disadvantage. 3 particular points from Medcalf are worth highlighting. First, judges are asked to make full allowance in the wasted costs context for the fact that respondent lawyers are not able to tell the whole story due to privilege before making a wasted costs order. Secondly, the respondent lawyers are entitled to the benefit of the doubt where there is room for doubt. A wasted costs order should only be made if the conduct of the lawyer is plainly unjustifiable. Thirdly, extreme care should be exercised by the court when considering whether it is satisfied that there is nothing that the lawyer, if unconstrained, could say to resist the order, and that in all the circumstances it is fair to make the order. Can the analogy successfully extend to professional liability claims? Well, in Medcalf, the court noted that there was a basic principle that a party should not be condemned without an adequate opportunity to be heard. Of course, that begs the question of what adequate means in all the circumstances. But if it means giving the lawyer the benefit of the doubt in the wasted costs order context, should it not also in the civil suit context? One answer to that rhetorical question is to say the regimes should be different, because in the wasted costs order context, the applicant is asking the court to exercise its discretion under Section 51 of the Senior Courts Act, whereas in a civil suit, the claimant is pursuing a cause of action as of right. An alternative answer might be to say that the claimant has the burden of proof in relation to the content of unknown privileged communications. But that might be tricky, depending on the facts, in terms of forcing a claimant to prove various negatives. And also, given a litigant's ability to prove facts by way of inference from surrounding circumstances, that might provide little comfort to a lawyer facing a trial. Finally, one option might be to say that the claim is simply not amenable to judicial determination. An analogy could be drawn with the public interest immunity case of Carnduff and Rock. In that case, a police informant's claim against the police for payments, which he alleged were contractually due for information which he had provided, was struck out by a majority of the Court of Appeal. Lord Justice Laws held, "It seems to me that these matters cannot be litigated consistently with the public interest, and if that is so, there is a plain jurisdiction to strike out the claim as embarrassing or abusive." He noted the issues in dispute on the pleadings and said, "It's upon these issues that the contest wholly depends, and once any such issue is raised, it is to my mind inevitable that the court's duty would be to hold that the public interest is outweighs the countervailing public interest in having the claim litigated on the available relevant evidence." And that approach was approved by the Supreme Court in Begum. It may be a question of fact and degree whether or not privilege issues mean a case cannot be fairly tried, or whether one party is merely placed at a forensic disadvantage, to use the language from Begum. But it may well be at least possible for a defendant lawyer to argue by analogy with the public interest immunity cases that a claim should be stayed or struck out because of the unfairness visited upon her. A claimant may say there is no proper analogy to be drawn between a client's private right to privilege, which may affect a lawyer's defence of a claim against him, and public interest immunity. But the response to that would be that the case law on the absolute nature of privilege shows that it ultimately rests itself on a public interest criterion, namely the ability of clients to consult their lawyers in confidence. That was described in Crown and Derby as a fundamental condition on which the administration of justice as a whole rests. It would take quite a self-effacing judge not to agree that there was a public interest in something essential to the administration of justice. Thank you very much for coming to listen. If you have any questions, please let us know.